Hi there, welcome. I'm Ben Olinsky, Senior Vice President for Structural Reform and Governance at the Center for American Progress, and we're so glad that you could join us today for 20 years of the Roberts Court, the Chief Justice's legacy and the coming term. We're on the cusp of the Supreme Court's new term, during which it will decide cases that profoundly impact the rights, privileges, and protections of every American. In recent terms, the Roberts Court has shown no compunction in overturning decades-old legal precedents, even as it expands presidential and corporate power. In many ways, we are now living in a nation fundamentally molded by Chief Justice Roberts and his right-wing colleagues. And this term will be no different. The Roberts Court is once again poised to undermine vital constitutional and legal safeguards that have long protected Americans from powerful special interests and government overreach. As we enter John Roberts' 20th year as Chief Justice, it is worth looking back on what he pledged under oath during his Senate confirmation hearing. 20 years ago, Roberts pledged to be a neutral arbiter of the law, to follow precedent and stare decisis, and to only call balls and strikes. He also stated that no man is above the law, not even the president. Don't believe me? Here is the Chief Justice in his own words.
My personal appreciation that I owe a great debt to others reinforces my view that a certain humility should characterize the judicial role. Judges and justices are servants of the law, not the other way around. Judges are like umpires. Umpires don't make the rules, they apply them. The role of an umpire and a judge is critical. They make sure everybody plays by the rules, but it is a limited role. Nobody ever went to a ball game to see the umpire. Judges have to have the humility to recognize that they operate within a system of precedent shaped by other judges equally striving to live up to the judicial oath. And judges have to have the modesty to be open in the decisional process to the considered views of their colleagues on the bench. It is what we mean when we say that we are a government of laws and not of men. It is that rule of law that protects the rights and liberties of all Americans. It is the envy of the world, because without the rule of law, any rights are meaningless. No man is above the law, not the president and not the Congress.
What a difference 20 years makes. One only need to look to the decision he authored in Trump v. US to see how far he has strayed from those promises. In that case, he effectively rewrote the Constitution, saying that one man, the president, is in fact above the law. That decision also gave explicit permission for the president to take direct personal control of the Department of Justice, meaning that he could direct investigations and prosecutions into political opponents and let his allies act with impunity. This decision set the stage for so much of what we're seeing today from the Trump presidency. In recent terms, Chief Justice Roberts and his extreme right-wing colleagues have also ignored the concept of judicial humility, seeking to overrule precedent at every turn. Instead of modestly evaluating the well-reasoned precedents of Supreme Courts past, the Roberts Court has been one of, if not the most, activist Supreme Courts in American history. Chief Justice Roberts has also created a new legal theory, the major questions doctrine, that makes it harder for the government to address emerging and novel challenges, even in cases where Congress has directed agencies to do so. The major questions doctrine has been a key component in this court's decisions that eliminate environmental protections, such as in West Virginia v. EPA, which made it easier for the fossil fuel industry to pollute our air and water. A few years ago, the Roberts Court overturned Roe v. Wade, a 50-year-old landmark decision that protected a woman's constitutional right to an abortion. This has led to 12 states banning abortion and several other states banning abortion at times when women may not even know they are pregnant. Chief Justice Roberts has authored crucial opinions that tore the heart out of Section 5 of the Voting Rights Act, which previously ensured that discrimination did not play a part in our elections. This court may be primed to do the same to Section 2 of the VRA this year in Calais v. Louisiana. Roberts joined the majority in Citizens United, which opened the floodgates of unlimited dark money spending in campaigns, giving deafening megaphones to moneyed special interests that drown out the pleas of the American public. And the current Roberts Court may well worsen this problem if it overturns the 25-year-old precedent that limits campaign coordination between candidates and parties in this term's case, National Republican Senatorial Committee v. Federal Election Commission. This term, the court will also threaten LGBTQ rights in 2 cases involving trans athletes, and a third seeking to overturn ban on LGBTQ conversion practices. And that is to say nothing of the Supreme Court's shadow docket, in which the extreme right-wing majority continuously decides, often without legal basis, in favor of aggressive actions by the Trump administration that are building an imperial presidency and harming millions of Americans. In fact, they often say nothing at all in those decisions. Justice Ketanji Brown Jackson rightly called what this court is doing with the shadow docket cases, quote, Calvin Ball jurisprudence with a twist. Calvin Ball only has one rule. There are no fixed rules. We seem to have 2. That one, and this administration always wins. I hope for a return to the modest and reasoned John Roberts we saw in the video a few minutes ago, the one who revered the rule of law and proclaimed that no man was above it. Each day he goes to work in a building with an inscription over its main entrance, equal justice under law. That motto is rapidly becoming a historical anachronism as we watch our cherished rule of law being replaced on Roberts's watch with rule by law. The question is whether Roberts will awake to that reality and course correct before it's too late. We have a wonderful panel with us to look back on Chief Justice Roberts' legacy and to unpack the many cases coming before it this term. And with that, I'll turn it over to our moderator and my friend, Devin Ambres, CAP Senior Director for Courts and Legal Policy, for introductions.
Good afternoon. Thank you, Ben, and thank you to everyone online for joining the Center for American Progress's retrospective look at 20 years of the Roberts Court and preview of the 2025 Supreme Court term. I'd also like to thank our amazing panelists for lending their time and expertise to this discussion. A bit of housekeeping before we start. We're going to have an audience question session for the last 15 minutes or so of this event, so please drop your questions into the Q&A chat function. Without further ado, I'd like to introduce our austere panelists. Professor Justin Levitt, Professor of Law and Gerald T. McLaughlin Fellow at the Loyola Marymount School of Law. Professor Chiara Torres Spelisi, Professor of Law at Stetson University College of Law, Go Hatters. And the Honorable Nancy Gertner, Senior Lecturer in Law at Harvard Law School. Thank you all for joining us. I'd like to jump in with a question that stems off of Ben's opening comments. We saw clips that alluded to what is perhaps Chief Justice Roberts' most famous quote, that judges are not ball players, but umpires who are there to call balls and strikes. He pledged that he would confront every case with an open mind and follow law and precedent. We are now entering John Roberts' 20th year as Chief Justice of the Supreme Court, and I wanted to get your thoughts on how well he and the justices under him have lived up to that pledge of judicial humility and adherence to not becoming the ball players themselves. Are there any specific cases that come to mind when you think of this pledge over his tenure? I'd like to jump in with Chiara.
Okay. First, thank you so much for having me. Because the Supreme Court has to deal with such a wide range of cases, it's difficult to generalize. But in my area of scholarship, which is political corruption, I have made the argument that the Roberts Supreme Court is deregulating corruption. The Roberts Supreme Court has moved the goalposts in white-collar crime cases about political corruption, including in Kelly, McDonald, Snyder, Percoco, and Simonelli. And the Roberts Court has also moved the goalposts in campaign finance cases by redefining what counts as political corruption as just quid pro quo in Davis, Wisconsin Right to Life, Bennett, Citizens United, and McCutcheon.
Thanks, Justin.
So rather than moving goalposts, I actually want to stick with the baseball metaphor that he proposed. And I actually think it's a really good metaphor. It's just that we didn't appreciate it as such at the time. There are 2 differences between that metaphor and the reality we're living. 1, the rule of law is not a game. And 2, it's straightforward to fire an umpire who misbehaves, and a lot less straightforward to fire a justice who misbehaves. So we know umpires don't formally have discretion to change the strike zone. It's basically armpits to knees in a natural stance. But anyone who has watched baseball knows that there's a lot of variation from batter to batter and from umpire to umpire. And an umpire setting the strike zone, unreasonably small or unreasonably large, can absolutely change the course of the game. And an umpire setting the strike zone unreasonably small or unreasonably large for just one team and not the other team can not only change the game, but destroy people's faith in the reality of the game itself. And I think that John Roberts, the umpire, has changed the strike zone, and not in a consistent way. The most present version of his role as a very activist umpire indeed is in the shadow docket cases that I know we'll get to. But he has, without saying as much, changed all of the standards for review of cases on the emergency docket in a way that very clearly leans in on the federal government gets to do whatever they want. And that is umpiring at its worst, I think.
Judge Gertner, you're still muted.
There we go. I want to chime in as well. It's not simply subtly changing the strike zone. It is explicitly reversing precedent. I began writing about this in 2018, but before Dobbs, when the court reversed the long-held view that paying agency fees, union members paying agency fees, did not violate the First Amendment. They changed that, and what was interesting is that Justice Elena Kagan, beginning to see the handwriting on the wall, said that they reversed the decision that had been entrenched in this nation's law and economic life for over 40 years. This is 2018. The next term, there were also cases in which they reversed precedent. Breyer writes a dissent in a Nevada case that granted California immunity from a private lawsuit. And he says he feels compelled in his dissent, clearly knowing what's coming down the line, to justify precedent. That's extraordinary. He says later appointed judges may come to believe that earlier appointed judges erred and may be tempted to overrule cases with which they disagree. They should resist this temptation. So by 2018, the three, quote, liberal, end quote, justices understood what was coming down the pike. And what was coming down the pike was a torrent of reversals. Most recently, Justice Thomas apparently gave a talk just this weekend in which he made it clear that he has no problem reversing precedents with which he disagrees, which delegitimizes the Supreme Court and delegitimizes the courts in general.
Thank you. I think there was a great opinion written by Hawaii Justice Todd Edens recently in which he analogized the balls and strikes, in which case he said balls that bounce off the ground are being called strikes. Balls that fly over the head of the pitcher or of the catcher are being called strikes. And that's what Chief Justice Roberts has done. And carrying on with what you said, Judge Gertner, I think Justice Thomas was a little more colloquial in saying, if I think it's stupid, I'm going to overturn it. So doesn't the law clearly, I don't think, matters. And so just kind of following up on that and the cases that they've overturned, we've seen them overturn 40-year-old precedent in Chevron doctrine in Loper Bright last year. They turned over the 50-year-old Roe versus Wade in Dobbs versus Jackson Women's Health. And last week, they effectively turned over the 90-year-old precedent of Humphrey's executor in an unreasoned shadow docket opinion that prohibits the president from being able to fire without cause members of nonpartisan and bipartisan agencies created by Congress. How does declaring past generations of judges, justices, and Congresses wrong, just flat wrong, without providing any reasoning, align with assertions that this court should in any way follow precedent and act with humility? Justin, do you want to jump in?
Sure. So, I mean, the short answer is it doesn't. I'll say that in and among the overrulings, I mean, you're right, there has been a profound number of cases in which they've overturned precedent. That includes, from my point of view, a good one. They overturned Korematsu, finally, but they did it in an opinion that refused to grant relief that the judges in dissent in Korematsu would have found very strange indeed. So I think rather than focusing on the formal overrulings, I think it shows just as much absence of humility in terms of the direction that they've taken cases which may not be squarely against precedent, but still are a very new and extremely conservative direction. Right? They have unquestionably overturned some very big precedents. You mentioned a few, and Dobbs probably lingers sort of brightest on the minds of most of the public. But they've also radically changed decisions on the use of race. They've radically changed decisions on access to the courts. They've radically changed decisions on when class actions can be brought and when people can seek joint relief from a wrong. They've radically changed the immunities given to members of the government, including the president himself. And even when those aren't overrulings, they are decidedly breaks with lines of opinion and lines of reasoning of decades past and demonstrate exactly the same lack of humility that we see in the simple X case is overturned.
Let me just also add, I mean, what the famous story about Brown versus Board of Education, which was, obviously striking a new path. The significance of that was that the court said, let's re-examine the precedent in the light of the data. Let's not say earlier justices were all where we disagree. And famously, the court struggled to make sure that that was a unanimous decision. There is none of that. So even procedurally, there's none of that. Let's evaluate this precedent and see where it has gone wrong in its operation over the past couple of years, as opposed to Justice Thomas's hubris in saying, I just disagree. That is a very different approach to the law than we have ever seen. And then your point, Devin, about the shadow docket, I talk to district court judges all the time. District court judges are dealing with essentially an incoherent path. Decisions in the shadow docket, which no one ever anticipated would be precedential, are now being considered precedential. So it's essentially ruled by the Supreme Court's hubris.
Let me add, since we're looking back 20 years, that it's worth remembering that the Chief Justice only has a single vote on a multi-member court, and that in his first decade, he had to contend with Justice Kennedy, who was the swing justice. And so he didn't have a reliable fifth vote for everything that he might have wished to enact through judicial fiat. But that changes, and we get Justice Kavanaugh joining the court. And after he joins the court decides Rucho versus Common Cause, which slams the courthouse doors in federal court to partisan gerrymandering claims. And then in the fall of 2020, we got the addition of Justice Barrett. And that really, I think, changes things, because now the Chief Justice has 5 justices to his right that he cannot control. And it's that court that we have today. And it's that court that, did Dobbs and overruled Roe versus Wade, did Students for Fair Admissions versus Harvard, which overruled Grutter, Loper Bright, overruling Chevron, and even more recently, Trump versus Casa, which gets rid of universal injunctions, which we had had for 60 years. So is any of that showing humility? I don't think any of that is humble at all.
I wholly agree. And to your point on getting rid of partisan gerrymandering, I actually wrote about that a decade ago, and think what I came up with what I thought was a very justiciable way of looking at that. But at this point, gerrymandering is just going to continue getting worse, and possibly even more so this term, which we will get to in a few minutes. But I wanted to carry on with regard to the shadow docket is the court has been incredibly busy over the summer, handing down numerous unreasoned decisions that almost without fail favor the Trump administration's policy priorities, favoring supposed equities that the administration proffered over real-world damages incurred by thousands, if not millions, of people and organizations that the government is now disfavoring. Last week, as we just discussed, the court effectively overturned Humphrey's executor by permitting the president to fire federal trade commissioners at will, which is directly on point because Humphrey's executor dealt with firing federal trade commissioners at will. And it also hammered Congress's power of the purse by permitting the president to withhold $4 billion of appropriated funding to foreign aid organizations, seemingly saying that the Impoundment Control Act prohibits these organizations from being able to effectively sue to get the money that Congress directed to go to them. So I would love to get your takes on whether this court's use or perhaps abuse of the shadow docket comports with anything that we've seen in American jurisprudential history and where we're going. And Judge Gertner, I'd like to start with you.
I think I like the promotion. I think when you think about it, there's always been a shadow docket. Obviously, the court had to deal with emergency issues for as long as it's been in existence. They were typically executions, that is to say, projected potential executions, scheduled executions that they had to intervene in. This is certainly a unique time. I think there are something like 300 district court cases that have been brought now challenging various Trump executive orders. So clearly, there's simply more pressure on the court with respect to its emergency docket than had been before. But by the same token, they have dealt with essentially these challenges in a disrespectful and cavalier manner is the only way that I can describe it. I wrote a piece last week in which I was supporting the judges, the district court judges, the one in particular who Gorsuch criticized, Judge Young of my former court, saying, you can't defy the Supreme Court, as if trying to figure out an unsigned paragraph, unbriefed, unreasoned decision is defying the Supreme Court. I analogize to the shadow docket to essentially rulings on the back of a napkin. Clearly the court had to do something because it was confronted with many more emergency petitions than it had. But the something it could have done was following the rules. The something it could have done would have been declined in certain circumstances, would have been following the framework for preliminary injunctions and TROs, in which the plaintiffs bear the burden of showing irreparable harm, and irreparable harm was all over these cases. That is to say, numbers of people will lose their jobs versus the government will be able to continue as it has. And instead, they have refashioned the rules with respect to emergency harm. They've taken cases which they had no business taking before they have been gone up through the district courts and the courts of appeals. So yes, it has been a moment of unusual challenge for the Supreme Court, but they have dealt with it about as badly as you can imagine.
Yeah, I think I don't disagree with you, but I just wanted to add that it seems that the court is looking as it is supposed to be balancing equities, and it balances none of the real world irreparable harm being incurred to the plaintiffs and puts all of the equities in favor of the government. And also, it would seem that with these massive changes that are being instituted by executive fiat, the prudent thing would be to maintain the status quo while the legalities are hashed out, rather than simply permitting the government to proceed unimpeded.
Right. The disruption is all on the side of the government here. The status quo, which has been in place for 50, 60, how many years, would counsel against taking these cases, certainly in an emergency setting. And the fact that they are really says something about Calvin Ball, about Justice Jackson's comment, which is, there appear to be no rules except for one: the government wins.
So I'll jump in if I can, and heartily agree with Judge Gertner on 90% of what you said and push back a little bit on 10%. The part that I'll push back on is I don't think there's actually pressure for the Supreme Court that's not of the court's own making. So we've had cases filtering through trial courts and courts of appeal going up to the Supreme Court on cert all the time. The normal course is you take your case through the court structure. And the normal answer for the court, the usual answer for the court, and most of the time the right answer for the court is no. Not no, you lose on the merits, or no, you win on the merits, but no, I'm not going to decide this right now. Stay in your lane. And for generations, the answer on the emergency docket was that's not our business. We let the courts do their work deliberately with briefing, with argument. We let judges write reasoned opinions. And we take the cases that we want to take in due course rather than jumping to an answer. I don't think there's pressure on the court to decide these things that the court is not giving itself, because the court has the option to just visit the cases as they come rather than jumping in. It's the court's eagerness to remake the legal structure, to remake the status quo, to remake power that has it actively interfering in cases that, and here's where I completely agree with Judge Gardner, it has absolutely no business deciding. I'll also say these decisions aren't decisions. They're power, not law. We let the justices wear robes because of their power to explain, because of their power to hand down rules that govern in other cases, and they're not doing any of that. They're acting very imperially. Caesar turning a thumbs up or a thumbs down before feeding someone to the lions, without any explanation of the why. If there's, and I'll say, I think that this is beginning to register with the public. I think the disruption's beginning to register. If there is one set of actions that's going to point the way towards serious court reform, toward undoing the Supreme Court as we know it and turning toward a different institution, or an institution that's configured differently, I think it's these shadow docket decisions, which are, again, when they're unexplained, when they're underexplained, it's one thing and bad. When they're unexplained, it's simply power and not law. And here, Devin, I'm going to push back just a little bit on something that you said as well. I don't think we can read into what those decisions are or are not. When the decisions come without explanation, the only thing that 5 justices agree on is that a particular order issued on a particular day in a particular case with a particular docket number is stayed. And that's it. Was it a substantive problem? Was it a merits problem? Was it a standing problem? Was it some defect in the factual record? We have absolutely no idea. That's part of why this is power and not law. And I think that the judges, as Judge Gertner said, struggling to make sense of this all, are doing the right thing when they ignore the power and follow the law. If there's active precedent on point, then judges have the responsibility not to try and guess what the Supreme Court meant, but to follow what the Supreme Court has said in cases where they're actually doing law and not just power. So your descriptions are right in what they have enabled the Trump administration to do, but those aren't legal rulings. We don't know that Humphrey's executor is overturned. We just know that when cases come up to the court involving the firing of a head of an agency, the court's going to do something very strange. But until they actually do the thing, I think courts have the responsibility to do law as they've been doing and follow the rules that the Supreme Court's handed down to them when they're actually issuing decisions on behalf of a majority.
Let me say I completely agree with you and your 10%, because the analogy to executions where the court has to move, where the court has to take action, versus these decisions where the court is choosing to take actions that you're absolutely right. They do not have to move on these cases except for the political pressure that they feel, which is precisely the pressure that they should not feel.
And I would add, we have to remember that the Supreme Court will tackle the big issues of the day on the merits. They're going to have to decide what birthright citizenship means. They're going to have to decide what posse comitatus means. They're going to have to decide whether the president can impound money. They're going to have to decide which tariffs are illegal. And I I understand the frustration with them using the emergency docket for precisely the reasons that were just articulated. We don't get reasons from the court, which are sorely needed. And then I think the other thing is bad actors get to do something bad for 2 or more years as the merits case winds its way through the lower courts. This happened in a case called Milligan about Alabama and its congressional maps. And the court, on its so-called shadow docket, allowed that bad map to be used in a congressional election. But the good news about Milligan is when it came back up to the court on the merits, the court actually ruled in a way that was consistent with the Voting Rights Act and told Alabama, you've got to redo your maps. So I don't want us to completely lose hope that when some of these cases come back on the merits and they have full briefing and full oral argument, that they can still get to fair and just decisions.
You're more optimistic than I am.
Fair. I want to move away from the general discussion about the courts and what they're doing to a slightly more specific topic. And Justin, this question's for you. And the court has done a great deal to strip protections from the American people and give seemingly unprecedented power to corporate special interests and even government overreach. Loper Bright and Corner Post have made it easier to challenge protections federal agencies provide to the public. And the major questions doctrine has made it infinitely more difficult for the government to address emerging and novel problems facing the country. Putting this into a historical and law nerd context, are we seeing this court revert to an almost Lochner era vision of rights in America, where it is corporate entities that have all of the power and government and individuals are restrained from actually enforcing the laws that attempt to prevent harms to the public and the commons? Where do you anticipate the court going in this and future terms in that regard?
So I'll say almost. The distinctive feature of the Lochner era were constitutional rulings that no elected body could overturn, right? The court had to reverse itself and famously faced a lot of political pressure in an expansion of the court that historians argue might or might not have helped them along the way toward turning the corner. If we had a functional Congress, most of the Supreme Court's decisions in the administrative state are not, I think, horrible in the abstract. Two very important asterisks there. They have given themselves more power to decide, right? Loper Bright essentially said the courts will tell you when a statute's ambiguous, and the courts will tell you when Congress wanted to defer to an agency, and the courts will tell you what a statute ultimately means. There had been, since Chevron was decided, giving agencies ostensible control over statutory ambiguities, there had been 40 years of precedent, with exception after exception after exception after exception, that really put the courts in the driver's seat anyway. And so I don't actually view Loper Bright, and I might be alone in this, as a sea change rather than the final step in a 40-year campaign to give the courts more power. Cases like Corner Post, which you mentioned, which allow essentially indefinite challenges to regulations, I think are much more dangerous. There is no settled challenge to a regulation anymore. Regulations can effectively be challenged at any point. And the major questions doctrine, this too, when deployed in the right way, is simply a check to make sure that agencies are doing what Congress would have wanted. It's essentially making sure that when agencies use a credit card they've been given, that the charge is authorized. The problem, I think, is not with the concept. The problem is I don't trust the Roberts Court to use those doctrines of checking in with Congress in any way that is even-handed. And I don't trust Congress to follow up to fix what the Roberts Court may have gotten wrong. Congress has proved itself to be, in some ways, uniquely dysfunctional in the last few years in particular. And although most of the decisions that the Roberts Court has been making in the administrative state are congressionally fixable, there is no sign whatsoever that Congress has any appetite to fix any of them. And that leads to a unique period of the court effectively making rules on which regulations it likes and which regulations it doesn't. And those are very Lochner-like. If we had a Congress that was standing up for itself, I'd be a little less worried. And in that assault on the administrative state, the one part that Congress might not be able to fix is what's coming next term, is the shadow docket preview of a remaking of presidential authority to fire agency heads despite what Congress has said. And in some cases, despite what Congress has said abundantly clearly. That sure looks to be, and I will hope that Professor Torres Pelosi is right, that it is not, that these are shadows of things that may be, but not definite promises of things that will be. That looks to be a remaking of the administrative state with an extraordinarily powerful executive and a Congress that can't do much other than meekly follow. That's dangerous. That has nothing to do with the original design. That has no basis in the text of the Constitution. It hinges entirely on the Supreme Court's vision of the words, the executive power shall be vested, and that's it. And this court has shown that it is way too comfortable with a uniquely powerful executive, and far more comfortable with a uniquely powerful executive than Congress has ever been. And that, to go back to the original montage, speaks to a profound lack of humility, both on its own part and a profound lack of trust in Congress that I think is wildly out of bounds for this court.
Would anybody else like to jump in before I move to the next question? All right. So for Chiara, 12 years ago, the Roberts Court dealt a major blow to the Voting Rights Act in Shelby County versus Holder, ruling that Section 5 is no longer functional. 15 years ago, the court's ruling in Citizens United effectively opened the floodgates to unlimited dark money in political campaigns. Two cases this term flow from that same vein. Calais versus Louisiana is challenging the constitutionality of Section 2 of the VRA, and NRSC versus FEC is asking to overturn a case from 2000 that limited campaign spending coordination between parties and candidates. How do these cases fit together, and what are the implications if the Roberts Court does indeed side with the challengers?
So in my area, which is campaign finance, the Roberts Supreme Court has been hostile to every regulation of money in politics save one, which arguably was an outlier because it had to do with judicial elections. So, and again, it really matters who is on the court. If you compare the Roberts Court to its predecessor, the Rehnquist Court, it's not as if Sandra Day O'Connor and William Rehnquist were big fans of campaign finance, but they were fair jurists. And if you gave them a thick congressional record or a voluminous case file, they would read it and they would treat it fairly. And I think that is what the Rehnquist Court did in a case called McConnell versus FEC, which upheld the Bipartisan Campaign Reform Act of 2002. But as soon as Rehnquist dies and O'Connor steps away from the court in order to care for her ailing husband, they are replaced by John Roberts and Sam Alito, who come to the court with this antipathy for campaign finance reform. And as soon as they get their hands on their first campaign finance case, they rule against reasonable reforms. And they've been doing that, ever since 2006. Similarly, in the area of the Voting Rights Act, there's plenty of evidence that John Roberts has hated the Voting Rights Act ever since he was a young attorney at the Department of Justice in the Reagan administration. And he has used his role as the Chief Justice to chip away at the Voting Rights Act in cases like Namundo and Shelby County. And we will see whether they continue on this path this term. So they may loosen more campaign finance regulations. I mean, I'm always worried when they have a campaign finance case in front of them that they won't just stick to the narrow issue that's presented by the case, but rather will use it as an opportunity to just blow up a huge part of campaign finance. This is essentially what happened in Citizens United. It started as this narrow case about disclosure of who was funding an anti-Hillary Clinton movie. And they set it for re-argument, changed the question, and they changed the question to, should we overrule McConnell? And I always get nervous whenever they have campaign finance cases on their docket that they'll do a second Citizens United, that we get Citizens United 2.0. And I'm also pretty nervous whenever they have a voting rights case on their docket, because they can ruin this piece of legislation that has been re-upped by Congress repeatedly, and they can leave it in tatters.
So I'll add to that, if I can, one other common thread, which is both of these cases are deeply weird. Like, just weird.
Is that a legal term?
That is a legal term. The National Republican Senate Committee is a case about a party that is in power across Congress and the presidency, contesting a piece of federal legislation they could eliminate tomorrow if they wanted, right? The Republicans have the power to undo the thing they're complaining about. And the thing they're complaining about is also a thing that doesn't do them any harm. The National Republican Senate Committee is complaining that it's not allowed to coordinate its expenditures with candidates. That is, it's complaining that it's not allowed to put out an ad that is whatever one of its candidates wants. That's not the committee's own speech. There is, thanks to a bunch of other precedent, no limit on the committee's own speech. The committee can put out as much of ads as it wants on its own message. It is only when it's trying to distribute somebody else's message that it encounters this particular problem, and that's a really small injury. It's not what the Republican Senate Committee wants to say. It's what somebody else wants the Republican Senate Committee to say. And if they wanted to get rid of this regulation, they could do it politically in half a second. And so I share, unfortunately, Professor Torres-Spellis's fear that what's going on here is not a narrow attack on this one piece of legislation, but a much broader deregulatory string, because otherwise they don't have to bring the case and the court doesn't have to hear it. On the Calais case, it's also deeply weird. They've set this case, which I thought was a very easy case. This is a case about race and politics and whether Louisiana drew the lines that it drew in order to preserve Speaker Mike Johnson's seat and a bunch of other Republican seats, or whether it drew because of race. I thought it was easy. Justice Thomas thought it was easy in exactly the opposite direction, which it turns out has made the case apparently quite hard. They've set it for re-argument, asking a question they have repeatedly answered over the last, in some measures, 60 years and some measures 30 years, about, is it okay to consider race in the drawing of district lines? And it's not only a question they've repeatedly answered over the last 60 or 30 years, it's a question they answered definitively 2 years ago. This is the case that Professor Torres-Spellis mentioned earlier out of Alabama, where there was a challenge to the constitutionality of the Voting Rights Act, and they said, it's fine. We actually think this complies with the Constitution. Now the court, or at least some members of the court, seem like they want to revisit that conclusion, and that too, I have a little more hope here than many of my colleagues, so maybe I'll be the hopeful one on this. I think nothing has changed in the last 2 years other than a presidential election. And certainly no facts on the ground have changed, and no member of the court has changed in a meaningful way. Justice Jackson is, I would think, a reliable vote for the continuing power of Congress to implement the 15th Amendment. And so I think that it may, when it considers the question, come back and say, just like it did in Alabama, actually, we think it's all fine. But it's deeply weird that they're taking so long to think about it.
Why would they take the case?
So this case in particular is up on appeal. It's one of the court's direct appeal dockets. They have to take the case somehow. They could summarily affirm, they could summarily reverse, but the decision below was kind of wacky. And summarily reversing is something that doesn't send that much of a signal. It's very odd to see the court just say reversed without explaining why. So I always thought that the court was going to hear this case and issue an opinion on this case. Why would they set it for re-argument is the really tricky bit, and I don't know the answer. They gave themselves a really crowded docket at the end of last term. This case was already put on pause. The decision below was put on pause. The elections were going to take place under a map that was pre-existing. And so if you're going to punt a case to this term without actually sort of messing with real world conditions, this would be the case to punt for another term and the case to rehear. That's a small thread of hope, but a thread of hope. I also think it's really hard to write an opinion on this case that doesn't immediately reveal itself to be political nonsense. If you're going to empower Congress to regulate based on race under certain conditions, and the answer as to whether you can consider race has always been sometimes. If you're going to empower Congress to regulate race in the drawing of district lines under some conditions, the thing that you'd use to do it, the statute that you'd write, the constitutional provision you'd write, is the 15th Amendment. If they're going to answer the question no, they're going to have to find a way to rule that the 15th Amendment is unconstitutional. And that's tricky because it's part of the Constitution.
So just to build on that a little bit, you said it's a deeply weird opinion below. Why would anything coming out of the Fifth Circuit be deeply weird? But also, I think that plays into something that we can discuss at a later date. But the new reimagining of what the 15th Amendment means is a very big thing coming from the right-wing legal community, that the 15th and 14th Amendments weren't meant to empower former slaves, communities of color, but actually meant to be completely colorblind, which seems to be the new argument that folks are taking up and some lower court judges are agreeing with. So putting that aside, I wanted to talk to you, Judge Gertner, a little bit about the downstream impacts of Trump v. U.S. and some of this court's other rulings on the shadow docket, where presidential immunity from criminal acts has been created whole cloth. It's not mentioned nowhere in the Constitution, and has not been part of any legislative or judicial finding in the nation's history. It also allowed the president to direct the Department of Justice investigations, which we're seeing as DOJ is dropping investigations into allies and pursuing political opponents. Just last week, former FBI director James Comey was indicted after the acting U.S. attorney for the Eastern District of Virginia was fired because he did not feel that there was enough evidence to put an indictment in. A new political appointee moved in, President Trump's former personal lawyer, dropped an indictment. And this kind of comes to what, in, again, law nerd terms, is the presumption of regularity. The supposition that courts give to DOJ and the government that they're acting in good faith, they're acting in candor, they're acting regularly. Otherwise, so as a former federal judge, I would be interested to know, how should courts, the lower courts and even the Supreme Court, be dealing with the fallout from these decisions? And how should they be looking at governmental irregularities that are happening across the nation as we speak?
Let me start with the immunity decision. Along the lines of what people have been saying now, our fellow panelists have been saying now, which is there was a judicial way of dealing with the immunity decision. And the judicial way would have been to say, we don't know the metes and bounds of immunity across the board, but this case is not immune. Instead, there's a moment in the oral argument where Justice Gorsuch says, we are coming up with a decision for the ages. And I fell off my chair at that point, because that's what legislators do. That is not what judges do. Judges decide the case in front of them. So the immunity decision, aside from having no basis in the Constitution, was also of a breadth which is far beyond what judges should do, particularly in an incredibly important case. The analogy, the concern is not necessarily the Comey concern, although that's part of it. But frankly, when I heard of the bombing of the Venezuelan ships, that felt like SEAL Team 6. I'm going to do it. You can't stop me. I don't care whether it's illegal. The Comey decision does fit within the immunity decision, which is to say that which you're doing, or that's what you're directing your Department of Justice to do is arguably an official act. The presumption of regularity, it seems to me, something I wrote about it really before the administration was before Trump was inaugurated, when I said, look at the enemies list of Kash Patel. Look at Trump's enemies list. Look at Bondi's enemies list. If a court gets a case involving someone on that list, it seems to me a court should look very carefully at the presumption of regularity. The presumption of regularity means that we assume that the government has acted in according to the normal processes. What are the normal processes with respect to the prosecution, which is that there's an investigation of a crime, not of an individual, but of a crime. You determine whether there's probable cause to proceed, and then you present that to a grand jury. Not you figure out who you want to get, and then you go through their mortgage applications and everything they've ever written to see if there's a way of getting them. I think we've seen in the 300 or some odd cases that have gone to the district courts, the courts have in fact second guessed the presumption of regularity in case after case. Because the presumption, in one nerdy way to describe it, has been rebutted by direct evidence of irregularity. There is direct evidence of irregularity with respect to Comey, which is you fire the Department of Justice attorneys who don't think that there's probable cause until you find someone who will do your bidding. So this is not circumstantial evidence of irregularity. This is direct evidence of irregularity. It's also direct evidence of vindictive prosecution, which is a concept that rarely succeeds exactly because of the presumption of regularity, because we presume that the government is not vindictive. Again, we have direct evidence of vindictiveness in the president's supposedly mistaken tweet to Pam Bondi saying, how come these people are not indicted? So yes, that has been the whole area has been enabled by the immunity decision. There's no question about it. And I think that the lower courts have been skeptical about Trump in case after case. When I left the bench, the first article that I wrote was an article about how the only pressure I felt as a judge was to duck. That there are all sorts of doctrines that to duck in civil rights cases, to find no meaningful basis for overturning a conviction. There were all these ducking doctrines, and I predicted that the courts would not stand up to Trump, and I was wrong. The district courts have been extraordinary, no matter who the judge is, no matter who appointed the judge. The courts of appeals, for the most part, has been extraordinary. So I think we're seeing a robust undoing of the presumption of regularity with respect to this court. And let me say one thing, that also one issue with respect to the lower courts. I thought that the Supreme Court would be different when it began to get not appeals, which were extraordinary, of temporary restraining orders, but began to get findings of fact and conclusions of law in preliminary injunctions. It would be very difficult to say to the district court, you were wrong in terms of the credibility decisions you made, in terms of the context that you saw in the facts. They've had no trouble doing that. They've had no trouble doing that. So while the lower courts may be developing a rebuttal to the presumption of regularity because of the facts on the ground, who knows what the Supreme Court will do.
I'd like to put a pin in that for just a second and circle back, especially with regard to the way that justices have been seemingly undermining some of the district and appellate courts across the country with their actions and even words. But we're running low on time for our conversation before we move to the Q&A with the audience. So I'd like to get just one more question in about the LGBTQ rights cases that are coming this term. Two involve trans athletes at the high school and collegiate levels. The collegiate athlete is trying to actually drop their case. because they're no longer involved in college sports and, in fact, dropped out of college sports because of the vitriol that they got as the result of these laws and actions taken by the government. And it's worth putting into context in that there are about 500,000 student athletes at the collegiate level. NCAA reports less than 10 are trans. There are over 8 million student athletes at the high school level. Less than 1% or approximately 1% of those are trans, and the statistics don't tell us whether they're trans males or trans females. And the other case is Childs versus Salazar, which could eliminate prohibitions on LGBTQ conversion practices across the country on First Amendment grounds. And this is just kind of a round robin, but Justin, we can start with you, and if we can keep it relatively brief. But what concerns do you have about both LGBTQ plus rights coming out of this term and the court's recent First Amendment jurisprudence with regard especially to Childs versus Salazar? Because we've seen courts say doctors can't talk to patients about whether they have guns in the house, but apparently now doctors may be able to engage in conversion therapy practices.
So I want to start really quickly by giving the Roberts Court, and maybe this is despite John Roberts rather than because of him, a tiny bit of credit in that in the last 20 years, there's been a revolution in LGBTQ rights, that there has been an acknowledgement of privacy in the home, that there's been an acknowledgement of the right to marry, that there's been an acknowledgement of Title VII rights, that there's been a string of cases that actually the court has completely remade, and in my view, for the inevitable and inevitably positive consequence of affording real rights on the basis of sex and gender and sexual orientation and gender identity to people who have not been on the receiving end for a while. And I would hope that that would continue, but I'm afraid that it might not. Far more recently, the Scrimetti case showed that this court's affection for LGBTQ members is bounded, to say the least. And their use of the First Amendment as a weapon against the traditional licensing practices of the states is quite concerning as well. If speech is everything, and if free speech is absolute, then that's going to put an awful lot of constraints on states' abilities to keep us safe and prevent those who are entitled to have a license to practice law or medicine or financial responsibility or the like, to prevent them from regulating people who might otherwise do us harm. I think there's real concern about the path of the court ahead, and I will hope that they find more in the last 20 years of where they've been on LGBTQ rights than I anticipate they might. That's the biggest loss that we felt with Justice Kennedy. I think we're going to feel repercussions of that for years to come.
Yeah, I would add most of the good things that Justin just mentioned were because of Justice Kennedy being that key fifth vote. And the court hasn't had that many cases on transgendered issues. I was hopeful when they did Bostock, but they did Bostock when Ruth Bader Ginsburg was still there. They did Scrimetti with Justice Barrett being there. And Scrimetti is really concerning. Arguably, they got the wrong level of scrutiny. I mean, I understand they're the Supreme Court. They get to decide what level of scrutiny they're going to apply. But it probably should have been intermediate because it involved gender. But they apply rational basis and then find this ban on gender-affirming care for minors rational, which I think is kind of nuts. I mean, it seems perfectly irrational to me that the state can tell an individual what type of puberty they should go through.
I will just add to this conversation. I agree with everything. Clarence Thomas was quoted this weekend, if the reporting is right, saying that Supreme Court precedent isn't the gospel, and that it can be overturned as the court weighs whether or not to revisit marriage equality. Goodbye, Justice Kennedy. I think that these cases will all be essentially a fill-up to the right, which will and rule against trans rights. Precisely because whether the court would go so far as to reconsider marriage equality, I think is not likely given if this court is as political as I think it is, that would be an extraordinary decision. Trans issues, however, precisely because the numbers are so much smaller, I think they will happily undo.
Yeah, I mean, they have been asked to overturn, or they've been asked to consider whether to overturn Obergefell. The cert has been requested. They haven't ruled on or granted it yet, but that is definitely a significant concern. But as you note, Judge Gertner, it is with such a small portion of the population, it's easier for them to be beat upon than a much larger portion of the population. So turning to audience Q&A, and I might come back to just a couple follow-up questions. I think the panel, all of you would agree that we're in uncharted waters from a jurisprudential and historical perspective. So what are you all thinking about with regard to mechanisms that can be engaged to begin realigning the umpires towards calling balls and strikes without drastically changing the strike zone, to go back to the original analogy? And to the extent that that means structural court reform, procedural court reform, how are you all thinking about that? Because I think it's something that a lot of Americans agree with, especially in regard to term limits, especially in regard to transparency and ethics and things like that. I'd just like to get a general thought if you all have been thinking about court reforms and what that could look like and how effective it could be in bringing the court back to its original intended Article 3 purpose.
I have written on term limits. We are the only the Western democracy with a high court that doesn't have term limits. There's the absence of term limits is ridiculous. I've also I was on the White House Commission on the Supreme Court, and I was part of the group that thought that the court should be expanded, understanding full well what that would unleash. There's usually a disconnect between the Supreme Court and the politics, but this disconnect is much more dramatic because of, in my view, the essentially the packing that Trump did in his first administration. And I also think ethics reform should be on the table. It is an indication that Roberts has no control over this court, that he has not been able to meaningfully affect ethics reform of any kind. This is now not in the area of doctrinal issues. This is simply governing his own court. There's also, and historians might want to look at this, the impact of moving for change, ethics reform, term limits, structural change, could then have an impact on the court in the same way as famously the court packing proposals of President Roosevelt had an impact on the court. So the pushback in these areas could well have an impact on the court, even if we don't affect change.
Justin or Chiara?
Yeah, so I'll add very quickly to that. I agree with everything Judge Gertner said. I also think that docket control has to be on the menu. I think that restrictions on the court's ability to issue emergency relief is on the menu. All of these things are things that Congress can do. All of them. Absolutely every single one. And this comes back to why elections are so very important. The right has focused on the court, has, I think, prioritized the court for a very long time. And that energy and passion needs to be met by people understanding that the members of Congress they put in place are the avenue to rein in a court that is wildly out of control. So in a way, this comes back to what we are willing to force on Congress, and therefore what Congress is willing to force on the court. But I think there's an awful lot on the menu, both substantively and procedurally, to bring this court back into line with what it's supposed to be doing, law, not power.
I guess I would just add that we should use our First Amendment rights while we still have them. That even I, who's been very critical of what the Roberts Supreme Court has done with respect to corruption law, before ProPublica's exposés, I would have not suspected them of some of the behaviors that have now been documented. And I think that is important. And putting, pen to paper, op-eds, law review articles, books that tell the story of this period are going to be key to getting out of this period.
And I can add lower court judges. So Judge Gertner focused on this before, that judges are trying to make sense of what's coming out of the court, and in many cases pushing back forcefully. And I think that is 100% not only necessary but laudable. As long as trial court judges and appellate court judges keep on doing law, that's going to increase the political pressure on the court to stop doing whatever it's doing. So there are a lot of actors that can exert some pressure. And I think the court has earned all the pressure coming its way.
Fair. To Judge Gertner's point about the only Western nation that doesn't have term limits, I worked for the Florida courts for a minute, and all of my judges referred to it as judicially imposed senility when they hit their retirement age. So,
Right.
So I wanted to turn a little bit about the way this court seems to be seizing power from the lower courts that we've talked about throughout the course of this, but also chastising judges that purportedly don't follow what have previously been considered non-precedential rulings and unreasoned shadow docket decisions. That I think that aligns with a bit in what Justin was talking about and Chiara was talking about with regard to the way that they're taking away Congress's power to act in various means. If Congress was more robust, perhaps there would be more pushback. But the Roberts Court seems to be acting very differently from different past iterations of the court, in the way that they're remodeling the separation of powers in this country and the way that the constitutional paradigm has worked for the last 2.5 centuries. Judge Gertner, can you comment on what you're seeing and how perhaps we can pressure either Congress or the court to kind of remediate and go back to, I don't want to say the status quo, but at least the originalist constitutional intent?
I don't know where to begin with that, in a sense. I mean, I take Justin's point about the shadow docket as whether Congress can make it more clear that the Supreme Court shouldn't take these cases, that is, these cases being cases that have not gone up from the district court, appeals court, et cetera, to sort of operationalize more concretely what the standards for the emergency relief ought to be, even though they're pretty well established. Congress could certainly do that, is not likely to. So, I mean, there has to be legislative change in order to turn this around, because the courts are doing what they can to follow the rules that they know. There needs to be, Congress needs to step up with respect to funding the courts. There's now a funding crisis with the courts. There's always been a funding crisis with the courts, but it has a different resonance now when there are threats to district court judges that are unlike anything we have ever seen. A reporter called me to talk about threats when I was on the bench, and nothing that I ever experienced in 17 years compares to what judges are facing now. So there's a money question, which is Congress has to support, make sure that they fund the courts to the full extent. And I think that what's remarkable is that the judges have in fact been pushing back. You mentioned it a moment ago. It's not just ruling against the administration. It's ruling against the administration after elaborate findings of fact and conclusions of law and extraordinary comments, which I have never, ever expected to hear from judges. I've forgotten the judge who said this when he talked about what the Trump administration was doing violated the statute, the Constitution, and any rule in the universe. I mean, they are speaking to the public, which is what the courts have to do in order to light a fire under the congressional branches. They have to make clear what they're doing and why they're doing it in a way that I don't think they ever had to before. But there has to be statutory change in order to keep things from going backwards.
Thanks, Justin. Chiara, would you like to jump in?
Well, I guess I would say it is fair for the lower courts to complain about the shadow docket and the court not being clear. I mean, the court not being clear is something that has been a problem perennially. I mean, it's not just a John Roberts problem. I mean, I would challenge anyone to read some Breyer opinions, which are so unclear to lower courts, or some Kennedy opinions where you can't tell what level of scrutiny he's using, which then becomes a problem for future cases and for lower courts. So I'm all for the lower courts raising their voice and saying, you've got to clarify this, because if you want to demand and expect that we follow the Supreme Court, then the Supreme Court itself has to be more clear.
And I'll just add, let's not give the Supreme Court more power than they're asserting for themselves. They're asserting plenty, and we don't need to magnify that. So 1 and 2 and 3 justice concurrences are not the law. They're individual opinions. They're worth what op-eds are worth, unless they're part of a majority that are where it's comprehensible what the majority is finding. I take the Noam versus Vasquez-Perdomo case, the ICE injunction case. The only thing the court did not decide that it was okay to racially profile. The court did not decide that it was okay for ICE to grab anybody because of the way they look and the language they speak. The court decided that one particular order on one particular day in one particular case was invalid, and that's it. And we got an extended, I think, shameful discussion by Justice Kavanaugh that and 650 buys you a cup of coffee. So the right thing for a trial court judge to do at this point is to follow the law and issue effectively exactly the same order that was the subject of the order that went up to the Supreme Court in a different case with different plaintiffs, in part because that order was substantively correct based on the law that exists from what we know from the Supreme Court. What Judge Frimpong in LA did followed the law, and whatever the Supreme Court has done, don't project ahead, don't comply in advance, which is the rule that we've all been setting for ourselves for executive encroaches. The same thing I think is true of the court. I'm not advocating that judges defy the Supreme Court. I'm advocating that judges give unreasoned decisions, orders, exactly the authority that they deserve, which is to say, follow the order. But where they don't make law, don't do the court's work for them. Judges shouldn't be guesstimating where the court's going to be. And I think you're starting to see trial court judges understand that their role is to follow what the court has said, not just what the court wants you to think that they might say someday.
Well, that's right, because the district court has no right to overrule precedent. And so if the decision is based on precedent, no matter how much the concurrences fulminate, that's what a judge is supposed to do.
Much to the chagrin of everybody who's been in freshman year algebra, we have to make the court show their work, as it were. So we are running up on time. If anybody would like to do 30 to 45 seconds of anything that you want to make mention of that we haven't discussed, we've talked about so many things in a broad range and wide of topics, but if we've missed anything that you think we should be looking out for this term, if you words of hope for folks watching in regard to perhaps this court standing up to the Trump administration on merits. Why don't we jump off, Chiara, please?
Sure. I would highlight the case from the Supreme Court of Hawaii that you mentioned earlier. It's Hilo Bay Marina versus Hawaii. And Judge Edens is just amazing in this concurrence. It is worth your time to read the whole thing.
It's a short 40 pages. Justin?
So there are points at which courts and justices reach their expiration dates. Chief Judge Taney issued Dred Scott in the 21st year of his tenure. And I think a lot about that as we reflect on 20 years of the Roberts Court. I think that the court is destroying its own credibility, which as an institutionalist drives me nuts. But I think it also points the way toward reform. The court is making it inevitable that there's going to be some sort of reform. It's going to be an issue in the coming elections, like it or not. And the court's doing that to itself. I also think it's important that we not imagine that the court is more powerful than it is. we hold an awful lot of agency to change what the court does. We hold an awful lot of agency to change what Congress does, which tells the court what to do. And we have to feel that power. We have to use that power by making sure that people hear us, that the court hears us, and not just that we hear the court.
Let me follow along with that. When people are bringing cases, that even if they are challenging the Trump administration, and even if they are ultimately squashed by the Supreme Court, either on an emergency basis or ultimately, there is incredible value to bringing these cases. We litigate issues in this country that no one else litigates, and the enterprise of bringing a challenge basically crystallizes the opposition to that challenged action in a way that sometimes the political debate doesn't. I remember when I was in law school, we talked about the expressive function of law. And so these cases, these challenges are critical, even if they don't ultimately succeed. These decisions of judges that are laying out in English, in clear language, what they are doing and why what the government is doing is wrong are terribly important, even if they don't ultimately succeed. So I think that while this has been a boon to litigators, and while it is an enormous amount of effort, I think we have to keep this up because this is a territory of political discussion as well.
Completely understood. Well, I'd like to wrap up by thanking Professor Levitt, Professor Torres-Spelliscy, and Judge Gertner for joining us today. And thank you to everybody who joined us for the last 75 minutes. We dropped a couple of links to CAP products about the presumption of regularity and the Supreme Court term in the chat if you'd like to get it. And as I have learned this week for the under 35 set who are not familiar with Calvin and Hobbes and Calvin Ball, I would commend you to go look those up as well. They're fantastic. So thank you all for joining us and have a wonderful rest of your Tuesday. All right.
That's them.
I'm leaving now.